I'm really delighted to be here. I just think the world of Amy Warrenberg, and I'm so excited to have the opportunity to come to UNH and see all of you, meet you, and participate in this conference today. I'm going to be taking the first half of our time together to talk about oral advocacy. And I know that the dean this morning made some really good observations about the importance of brief writing, and I totally agree with him. Brief writing, in my opinion, is really the core of litigation and advocacy. But I also think that oral advocacy has its place in the law school curriculum, and it is certainly part of what it means to be a good lawyer, because being a good lawyer is very much about effective communication. And so I'm really thrilled to be able to teach appellate advocacy every fall, and I am the faculty advisor to the Blue Court program at Marquette. And when my students ask me why they should take appellate advocacy in the fall at Marquette, I tell them that I love teaching brief writing, but I think it's extremely important for them to understand the relationship between trial level brief writing and advocacy, and also appellate advocacy and standards of review and all of the good things related to that and the additional writing practice. But I tell them that what I really love about that class is that I get to work with them on their oral advocacy. And I've noticed that a number of students, in particular sometimes my very best students that I've had in the first year of legal writing, are often the most nervous to do public speaking. And so I really want them to have that opportunity to practice public speaking, because they may not take trial advocacy, which is really one of the few other courses where they have that opportunity to practice oral advocacy. So we have about 80 to 90 students every year that take appellate advocacy among the 4 sections that we offer. And I'm really happy about that, because I think that a large number of our students are coming out being pretty well-trained public speakers, which they can then use not only in the appellate context, but also as trial-level advocates, or even in their negotiations, or whatever kind of public speaking that they have to do. It gives them that extra practice. So I wanted to kind of explore that with you today, and my talk is called Fresh Ideas. I don't know how fresh they are, but they were fresh to me in the last few years that I've been working with them. But I'd really also love to take the opportunity to hear your ideas, not only about how to develop oral advocacy in the classroom, but also if you coach in court or you work with some sort of competitive team, what do you do to get your students ready? Because I'm very competitive and I like to learn from you. Quite honestly. So with that in mind, I actually wanted to ask you a couple of questions first. How many of you teach some form of oral public speaking or oral advocacy in your class? Super. Okay, good. Well, I'm happy to hear that, because I was my nightmare last night was that everybody would sit silent at that moment. I came here for that. So that's great. How many of you teach appellate advocacy? Great. How many of you coach a moot court team? Great. How many of you incorporate it into like the first year curriculum? Super. Okay, awesome. That's very helpful to me. Okay, so I loved this idea of practice ready, and I actually looked up on the internet, what does practice ready mean? You know, I'm all about definitions. We were talking about that last night, of the importance of definitions. And I found this article about New York State Bar asks the ABA to support practice ready in law school education, and of course we now know that the ABA has made some pronouncements about that in the recent time. But this article said that what the New York Bar said in their letter to the ABA is, quote, "We used to think that being a good lawyer simply meant knowing the law," Doyle and Younger said in a report submitted to the ABA. "Today we are more likely to think that good lawyers know how to do useful things with the law to help solve client problems. Accreditation rules should emphasize how to apply theory and doctrine to actual practice, i.e. oral advocacy, as well as encourage the process of developing professional judgment. These are critical skills that all newly admitted lawyers should have as they embark on their legal careers." Then it also says, "All this is an important complement to intensive in-class learning. In the classroom, students engage in doctrinal analysis of cases. In the field, they apply those abilities to complex, fact-rich situations representing actual clients. As students develop critical problem-solving skills interacting with clients, they become powerful advocates." So I wanted to focus today, as my theme, really on what I have learned, which is the most significant thing, to incorporate these concepts into the classroom, and really using classroom time as an opportunity to engage in practicing their oral advocacy skills. So really maximizing student time in class. The other thing I wanted to mention, and I'm so happy to see that Sophie's here, Sophie Sparrow from UNH Law School came to speak at Marquette just a couple of weeks ago, and I was really excited to get to meet you, Sophie. And as part of her presentation, she showed us a triangle of learning. Has anybody ever seen that? Where it talks about how the more engaged students are in the classroom, the more they're going to learn. And at the top of the triangle, you learn that 70% of retained learning in the course of 24 hours comes when students speak. 90% comes when they speak and do something with the material. So if you want to retain 90% of the material 24 hours after you've learned it, you should be doing something with it and you should be speaking about it. Right? Did I get that right?
Yeah, you got it. Absolutely, absolutely.
So I thought that was a really great, great point, and it bears to mind the idea that practicing speaking in the classroom, whether it's something informal like just raising your hand, or having a more formal public speaking experience, is extremely important for the students. And then just a little bit about the Marquette program. Students take appellate advocacy in their fall semester, either as a second or a third year law student. We have a 2-semester required course, but students are strongly encouraged, and almost, I would say, 90 to 100% of students take some sort of a supplemental third semester. And a lot of students take appellate advocacy, and that's the gateway program to then do an intramural competition in the spring, which we call our Jenkins competition. It's an honors competition. This year, Justice Kagan is coming to be our final round judge, so that's very exciting. Can't wait to meet her. And then in the third year, students do national competitions. And anybody who participates in the class is eligible to participate in the competition, so we have quite a few people doing it. So I'm going to talk a little bit about, or quite a lot about, what we do in class to prepare students, but also something about how we set up our core program in terms of preparing students. Okay, so just to make this a little bit more interactive so you can see and do, let's see if we can come up with a very short list of some of the strengths but also weaknesses that we see in students just in terms of their public speaking when they come to law school or when we get them in class. Does anybody have any ideas about that? What are some of the good things we see or hear from our students in terms of their public speaking?
Good things?
Yeah, good things. Yes.
I think they're often very passionate. They're excited to be putting a lot of skills together, and that really comes across.
Absolutely. They're passionate about advocacy, right? I can't tell you how many of my students say, oh, I'm so excited to get into advocacy or the advocacy component of the class because that's what I came to law school to do. Very good. So they're passionate. So they're interested in learning how to do this stuff. What else? Yes.
I think that when they're actually practicing, the vast majority of students demonstrate intuitively that respect for the court, so they intuitively do adopt that respectful tone, even if they may not always listen to the question.
That's great. They understand intuitively that the judge is an important person,
Yeah.
right? Absolutely. Very good. Yes.
They have the self-confidence to challenge their professors.
Great. Which is a great skill to translate into using some critical thinking skills in terms of responding to judge questions as long as they're respectful in how they do that. Very good. Okay, how about some of the things? What are some of the things that, bless you, that we think we should be working on with students to develop them more?
Nerves.
Absolutely. Like my student who graduated first or second in her class and told me that she was deathly afraid of public speaking. She went on to participate in the National Appellate Advocacy Competition and was at the Nationals and did great. So, you know, she really was a success story, I thought. Yes?
I think they have to be really dramatic and dynamic in order to get attention.
Right. And that there's a distinction between trial level advocacy, how you deal with the jury, and appellate advocacy too. Very good. Yes?
Listening. They don't always listen to the questions asked, but the surface and the subagenda.
Absolutely. Huge. Sophie?
Organization, you know, not getting to the point quickly and articulating it concisely.
Absolutely. And in fact, wasting a lot of time if they're not able to convey things quickly. Yes?
Adaptation.
Great. And what do you mean by adaptation?
Their ability to respond to questions, to change their argument, to change their starting point in an argument, in a particular point, to move on to another point.
Absolutely. The ability to maneuver through the questions, keep the organization in their mind, and go back to what they need to do, be responsive to judge questions. Yes?
Their use of informal language, they don't really listen to themselves in the manner in which they speak.
Yes, absolutely. We've talked a lot today about use of client letters and emails and how students are not being respectful in that, and I think that that comes through in their oral communication as well.
I call it informality. They speak in their manner of speaking is too formal, word choice, etc.
Exactly. Okay, this is a great list, and I think it's a really good starting point for us in terms of thinking about some tips and techniques. So, if you have the handout that I wrote, this one, I have 10 tips on here, and I put the ones that I'm really particularly interested in talking about today at the beginning, but I'm hoping to quickly touch base on all of them. The first one, and this may seem very basic, you probably are already doing this, but to me it was kind of a new thing when I started teaching this course, because I'd never taught oral advocacy before, is to provide in-class practice time with feedback. Do all of you do that? And I have to say, I've always done that in my appellate advocacy class from day one. However, I really pushed the practice times to the very end of the semester, right before the students were doing their final, evaluated experience. And then my husband, who is a really gifted trial advocate, started to teach trial advocacy at the law school as an adjunct. And he would come home and say, oh, well, all we do in class is we practice the whole time. And I give them feedback as we practice, and we spend maybe 5 or 10 minutes during the class where I give them some instruction. The whole rest of the time is practice, practice, practice. And that, to me, revolutionized the way I teach the class, because that's what I do now when it comes to oral advocacy. I do very, very little lecturing on the topic and a whole lot of in-class practice. In addition to sometimes I have them review short tapes of their own practices or of professional oral arguments. But the vast majority of the time, 90% of the time, they are the ones who are doing their class practice. And what I like about that, and it's really the same thing with written advocacy, what I like about that is that all of their practices bring up all of the problems that they need to fix. So instead of hearing me talk about it or trying to come up with a list of problems, they generate them themselves. And that is very helpful for them to see it and to catch it in the moment. So that's my fresh idea, number one. Number two, break practices down into smaller increments. So what I do is we spend one day on just the introduction, another day on a couple of days on the main argument, another day on the closing portion of the oral argument, another day on rebuttal, and then we spend actually quite a lot of time on responding to questions, several days worth. And I guess that's probably intuitive, but I wanted to point out to you that I read a book this fall called The Talent Code. Has anybody read that? The Talent Code. It's actually on the back page here. That book was amazing. And if you happen to want to read more about it, I did do a blog about it. I'm on the Marquette Law School website. It gives you some background on the book. But basically it's about teaching skills. Whether you're teaching somebody to play the violin or soccer or hockey or oral advocacy, this book is a great book on how to teach skills. And one of the key things that the author talks about is that you have to engage the students in deep practice. And deep practice is practice that really means something. And there are 3 ways to do that according to the author. The first one is to chunk the learning process. That's the term that he uses. And really what that means is doing very, very small increments of the practice. So if you're learning how to play a particular piece on the violin, you might practice the first line of the piece over and over and over. And apparently schools like Juilliard do that. And the students actually learn a lot more quickly when they break it down into those small pieces. So if you can do that with your students, to break it into something manageable and have them repeat that process, that's very helpful. The second is to really respect the process, that the students need to respect that process, that they need to be practicing repeatedly. And then the third is to reach a point where they can be self-aware of when their practices are effective. So I actually have talked about that with my students this semester after I read the book, and I think they found that very helpful, and I would recommend that you read that book too. Okay, the third point is focus the students' arguments on why the court should rule in their favor. Seems intuitive. I really like to talk about that with regard to 2 terms that I use with my students. The first is something that I call rule advocacy. Really, how do you advocate for the court to adopt the rule that you want it to have? And we talk about that in the course of the brief, and then we translate that into the oral argument. And I tell them that's the key focus. And you want the court to understand how and why it should adopt that rule, and also what the broader implications are. And if you can do that, then you're going to have an effective argument in terms of the substance. Okay, the 4th point, pair students with student coaches from your moot court board. That is something that I'm really, really proud of, and is my number 2, I guess, fresh approach. Does anybody do that? Do you guys do that at your law schools? You do? Great, awesome. So what we do is we take our 2L or sometimes 3L appellate advocacy students, and we pair them up with a coach that has already gone through the program. So typically a current 3L student. And our moot court board gets credit hours for doing that. And so usually they work with 1 or 2 teams, and the teams are paired already, so they're working with no more than 2 to 4 students. They have to meet a certain minimum number of times. They have to meet 5 times during the semester for 5 different practices. One of those practices has to be an off-brief practice, and then we have an additional panel weekend where the moot court board puts on oral arguments where the students are paired up, to appellate to appellee groups. So what I like about that, I've really noticed an enormous difference in the quality of the final round arguments from before we work with the coaches to after. What I like about it is just that the students are really literally forced to do some formal practices, and they have to sign an affidavit at the end of the semester that they have accomplished this. And what I also like about it is the wonderful connectivity that it brings to the 2nd and 3rd year students. They're really getting to know each other, they're working with each other. The students who are in the 3L national competitions or on the board are very much engaged in this process, and they learn something too by having to coach the students. So I think it's a really nice opportunity, and I've noticed huge improvement in the skills of the students at the end of the semester. Sometimes there are some interpersonal conflicts, which will happen whenever you pair people together, but they're very few, and students are able to work them out. And it presents an opportunity for teaching professionalism too, if that kind of a thing arises, but it almost never does, and it's just really been a very effective tool. Okay, ask students to observe oral arguments. We have oral arguments on the Wisconsin Supreme Court website, so that's easy for us. You can listen to oral arguments at the U.S. Supreme Court. We have videos of past Jenkins competition final rounds, so we have the students watch those, critique them, and then we have the National Moot Court competition in the fall at Arcade. We have one of the regionals. In fact, Mary was at the regional this fall. And we require our students to attend that, and they have to sign in. So that's a really great opportunity for them to see very good student oral arguments as well. The next point is that we have actually worked our oral argument practices in much earlier in the semester. We used to, as I said, push it kind of back to the end of the semester after the students have finished writing their briefs. Now we actually bring it in fairly early in the semester because the students have told us that they learn so much from practicing the oral argument and really having to talk through the argument that it makes their brief writing much better. So we incorporate it on some level before they have to hand in their final brief. I also have them come to my office and do a practice round too, which you're probably doing as well. The seventh point is to develop positive feedback for the students. In my class, I actually give instructions, written instructions to the students when we start the oral argument practices that tell them that they need to provide both positive and constructive criticism to the students. A lot of the feedback comes from the students in the class, so when somebody gets up to do an oral argument, I give some feedback, but I wait until after all of the students have had a chance to respond if they want to. And I'm so impressed with them. They always give really heartfelt, good advice to their classmates, and they start out with positive feedback and then they give the constructive criticism. We also established a tradition where no matter how small the little bit is that the student did that day, like they did their 2-minute rebuttal, and that's it. We all clap at the end. So that is really great because it really gives everybody some positive feedback and also gives them the confidence to get up there and do it in the future. And I always say if they can get up in front of their class to do this, they can get up in front of the other judges too. Separating comments on substance from comments on style. Just as we try to give positive and constructive criticism, we also, students are required to give substantive comment about the argument itself as well as stylistic commentary, which I think is helpful to keep in mind. The ninth comment, the ninth point, really relates to something I already talked about, that we have a minimum number of required practices. I also, as part of that, require the students to learn each other's arguments. I may not make them practice each other's arguments, but I do ask them to come up with questions for their partner so that they can be informed when they're practicing together on their own. And that relates to my final point, which is on the back page, which is to keep a running list of student-developed questions. So one of the very first things that we do when we start talking about oral advocacy, and this is very important to do before they hand in their brief, like when they're about a third to halfway through writing the brief, is we start coming up with a running list of questions for each side and each issue. And what I do is I put them into groups based on not who their partner is, but rather what their issue is and what their side is. So if they're representing the appellant on a Fourth Amendment issue, those people all have to work together and do some group work to develop questions that they may be asked, as well as what the answers might be. And we keep coming back to that throughout the semester. I may put them into those same groups again, or we may revise and add to our list of questions. And it's great to have that list because they can use it, their coaches can use it, and I can use it in terms of having good questions to ask. And it really helps them to think very critically about what's going on in their problem, and it helps them to develop an opportunity to communicate with each other about it too. So, a couple of sources besides the talent code. I use Mary Beth Beasley's book. It's just fantastic. Do most of you use that book? It's just really the #1 source, I think, for teaching appellate advocacy. But I also like the David Frederick textbook on oral advocacy because that contains a number of transcripts from U.S. Supreme Court arguments. And I get very positive feedback about both the Beasley and Frederick textbooks. Does anybody use the Ruggiero-Aldiser textbook, Winning on Appeal? That's a great source. I don't require it anymore, but I do have it as a recommended reading for my students. Judge Aldiser is I think he's retired now, Second Circuit judge who has written quite a few textbooks and articles. Winning on appeal is really all about what do judges think about written advocacy and oral advocacy. So it's a great chance to hear from the source about that. Just really quickly, here's one handout that I use in class. You're welcome to use it. And it goes through some of the techniques that we talked about in class more substantively. And then if you go to the website that was created, I put these two handouts on there, and I also have a PowerPoint that you're welcome to use on converting the brief to the oral argument if you'd like. It's the first thing that I use. And then I have the little form that I keep the running list of questions throughout the semester, so that's there as well. Any questions, or is there any questions at the end?
I think we're reserved.
Okay, great.